thank you everyone. I think we're about to get started. Go ahead and finish up eating. If you haven't signed in, we're going to send around a sign-in sheet, so please be sure to sign that. And if you are doing this for CLE credit, please come see me at the end so we can give you your certificate. If you don't know about the Liberty Project, it is a pro bono student group here at the law school, and we're also a think tank made up of law students, young attorneys, and other people in the community that are interested in reproductive rights and sexual health. It's been my great pleasure to serve as president of the Liberty Project for the last 2 years. My name is Erin Collins, by the way. But without further ado, I'd like to formally hand things over to our president-elect, who will be taking over next year, Corey Tishkin.
Hello, my name's Corey, and I am so proud to be here to honor the Liberty Project. To my immediate right here is Miss Loretta Ross. Loretta was co-founder and national coordinator of the sister song Women of Color Reproductive Justice Collective, a network that organizes women of color and allied organizations in the reproductive justice movement. Ms. Ross is an expert on women's issues, hate groups, racism and intolerance, human rights, and violence against women. Her work focuses on the intersection of social justice issues and the resulting social change. Ms. Ross has written extensively on the history of African American women and reproductive justice activism, including as co-author of the book Undivided Rights, Women of Color Organized for Reproductive Justice. She is a graduate of Agnes Scott College, holds an honorary doctorate of civil law from Arcadia University, and is currently pursuing a PhD in women's studies at Emory University. Aside from 40 years of social justice activism, Ms. Ross is also a mother, a grandmother, and a great-grandmother, and we welcome her to the Sandra Day O'Connor College of Law. To my farther right, Larry Hammond is a 1970 graduate of the University of Texas School of Law, where he was editor-in-chief of the Texas Law Review. He is a founding partner of the Phoenix law firm Osborne Maladon. He also co-founded the Arizona Justice Project, for which he serves as chair of the board. The Arizona Justice Project is Arizona's Innocence Project, and just yesterday, Mr. Hammond was here speaking to us about the Justice Project's great dedication and ultimate success in freeing Mr. Bill McCumber. Mr. Hammond has been a practicing attorney for over 4 years. Among his many accolades, Mr. Hammond was named a 2013 Lawyer of the Year in Criminal Defense and was inducted into the Maricopa County Hall of Fame in 2008. Mr. Hammond served as law clerk for Justice Lewis Powell from 1971 to 1973 and assisted the justice during the 1973 decision of Roe v. Wade. We are pleased to have this local legend here with us today to speak about the societal impact on the decision. And Ms. Ross is here today to speak about the decision's impact on society. I hope you enjoy the panel. Yes, please, Mr. Hammond.
Good afternoon. I was here last night and I don't remember going home. But I'm very happy to be back here today on an entirely different social justice topic. I am going to keep my remarks brief. I'm happy to answer questions, but I frankly came here today to hear Ms. Ross, and the less time I take talking, the more time I'll have to hear her. You all are extraordinarily fortunate to have her here with us today. I was asked to talk briefly about the impact of social change and the environment on the Supreme Court's decision in 1973. And I have thought a lot about what to say about that, and maybe the most helpful thing I could do is to take a minute and tell you the part of this that I am comfortable talking about. Lewis Powell, as you may or may not know, turned over all of his papers to the law school at Washington and Lee in Virginia. And his papers are now available online. You can inspect them anytime, and there is quite a lengthy section on Roe v. Wade. I heard this picture was going to be up here. I do not know any of those gentlemen. Seem to be slightly unkept. Those were my co-clerks, J. Harvey Wilkinson, who went on to become a Fourth Circuit judge and eventually Chief Judge of the Fourth Circuit, and Bill Kelly, who has become one of the great public servants in the history of Washington, D.C., started a number of very significant housing projects, and then there was me. So when I think back about this, I think about Powell's decision to turn over all of his papers. And when he made that decision, he talked to his family of law clerks and said, I want you to understand that you can always talk about anything I said to you or anything you said to me, but I would ask you to observe the confidences of what you may have heard other justices say. Justice Powell didn't feel like he had the right to interfere with whatever confidentiality decisions other justices had made. But I think the window into what Lewis Powell thought may be helpful to your conversation today. Powell came on the court in December of 1971. I was his first law clerk. He inherited me from Hugo Black. I didn't know if Black was going to survive his term, and he didn't. I didn't know if Lewis Powell would keep me as a law clerk, but he did. And on the first day of our clerkship with him, he had a meeting with us. And he said, I want you to understand that on any issue having to do with the Constitution, I would like you to assume that I, Justice Powell, don't know the answers. I may have written or said things before I became a justice, but those things were not informed by a knowledge of the Constitution, and I want you to work from the ground up on all constitutional law questions that come before the court. And I would also like you to know that I start out this job on the court with a belief in stare decisis. I want to start out assuming that the decisions of the court are meaningful, and that I intend to abide by them and follow them. I also think the words of the Constitution are very important, and I'd like to be guided by them, but I'd like to have your help on everything that you feel like you can help me with. Parenthetically, he also said, by the way, I know a lot about antitrust and tax, and I'll take care of all of those cases, and you will never have to worry about them. This was like warm water washing over the law, and we would never have to do anything but play with common law and criminal law questions, and he was very true to that promise. As you all know, Roe was argued twice. It was held over at the end of Powell's first term. I stayed with Powell for his second term. He served for 16 years. He only had one law clerk who stayed with him for more than a year. After I did it for 2 years, he decided he wanted to have one-year law clerks, and he didn't make that mistake again. But I did work with him very closely on this case, and when he left at the end of his first term to go back to Richmond for the summer, he called each one of his then clerks in and said, I'm going to give you a case that I want you to work on for the next term. The case he gave to me was Roe v. Wade. And he said, I want to understand as much as I can about that before the case is argued next year. And I'm going to work on it a lot myself over the summer. So that's what he did, and that's what I did. And then that gets me to the question of the relevance of current events in 1973 to the women's movement as it was emerging in those days, and to real life experience. I think if Lewis Powell were with us today, he would say he tried to set all of those things aside. And I think he would say that the other justices with whom he conferred approached it the same way. And I don't know what I would say if he said it, but that was certainly the way he approached it. And if you look at the ultimate Supreme Court opinion, the only part of it that really resonates in the direction of at least what Lewis Powell thought in 1973 was really two things. One is the cases that the court had already decided. People may hate some of those old cases, but the truth is that there was a body of case law that had developed by that time that betokened a right to privacy, a right to choose, a right to exercise reproductive rights. And Powell took those cases seriously, as did the majority of the court. Powell also was very interested in the meaning of the word life in the 14th Amendment. And he wanted to know if there was any law or literature out there that would answer the question, what did the authors of the 14th Amendment mean, and what did the authors of the 5th Amendment mean when they used the word life? And his answer ultimately came down to there was no evidence that the authors of those parts of the Constitution really ever took into account anything other than life after a child was born. Whatever else people may think about it, Powell couldn't find any historical evidence that life meant something else. So for those people who argued their case in the court, who said life must begin at the moment of conception, he couldn't agree with that. For those who said there was an absolute right to choose, he couldn't agree with that either, but he couldn't abandon the cases that had been decided. And so from the very beginning, he was on the side of saying that we need to recognize that a balancing is necessary here. How we got to 3 trimesters, I could never explain. Not because I wouldn't, but because I don't know how. But certainly, having said all of that, the real life experiences of people, of course, they matter. Lewis Powell had 3 daughters. One of them was the president of Right to Life for the state of Utah. He was influenced by his background. There was a great story that some of you may have read somewhere about his messenger, a black gentleman whose wife had an abortion and died in the course of what he knew was a backroom abortion. It would not be possible to say that those kinds of things had no influence on him or on anyone else on the court. But I will say that at least in Powell's case, and I think in some of the others, there was a real effort to try not to be influenced by the things that we all know are relevant life experiences. So with that, let me turn this over.
Thank you. Good afternoon. How y'all doing? I am very, very pleased and honored to be here. And I wasn't quite sure how I was going to start off my presentation, but that newspaper clipping that y'all had up about the Dalcon Shield actually gives me my entry point, because 40 years ago, I was implanted with the Dalcon Shield, which quickly ended up sterilizing me. I ended up suing the makers of the Dalcon Shield, A.H. Robbins, for the forced sterilization at the age of 23. And as a result, my individual lawsuit paved the way for the class action suit that thousands of women then launched against the Dalcon Shield. And so that became my how did I get into this activism story. Because I have to honestly say, I was pissed off. It was not a happy story to be told in your early 20s that you will never have any more kids, and the doctor can only say, oops. But it was, in another way, caused me to redirect my life into feminist activism, because up until that point, I had majored in chemistry and physics and thought I was going to end up in some sterile lab somewhere. And I'm very glad that I was introduced to feminism rather than ended up being sequestered. I'm sorry, segregated. I don't want to use that word today. You're right, instead of being isolated in some laboratory. So I guess it's very appropriate that 40 years later I would be here to talk about the impact of Roe v. Wade, because until this moment I had not realized that 1973 was so significant, both for me personally, but also, of course, for the movement that I'm a part of. Now, in 1973, when the original Roe decision was handed down, African American women responded to it probably a little bit differently than our mainstream counterparts, who for the most part were white. Largely because we welcomed the decision, because by far the majority of women who were proven to have died from illegal abortions were either black or Latina, according to the women going to hospital for septic illegal abortions. And so I even read statistics at the time that said that a black woman was 13 more times likely to have died from an illegal abortion before Roe v. Wade than a white woman. So obviously we viewed the decision with a lot of relief and a lot of joy, but also some skepticism. As a matter of fact, the National Council of Negro Women in 1973 observed that because we were at the height of the civil rights movement at that time in the 60s and the 70s, they asked the question, how was Roe going to keep black women in the South from being arrested for trying to vote? Because that was what was happening, particularly in Louisiana. Black women who were trying to exercise their right to vote were often threatened with removal of their children. Just by the act of wanting to vote, courts were presuming that they were unfit parents for their children. And so they drew a little skeptical veil around. Roe is not the panacea for all black women's problems. And that made us both happy that it happened, but also drew attention for what Roe didn't do. And I would add that Roe, since then, has not protected access to abortion in a way that the Hyde Amendment has certainly demonstrated. For those of you who don't know, in 1976, Congress passed a law that federal funds could not be used to pay for abortion, and the Supreme Court upheld that decision in 1977. And so since then, poor women have been discriminated against when they seek abortion care because they cannot use the health care plan that they have to seek abortion, whereas middle-class women whose health care is not dependent upon the federal government can seek abortion services. And this not only applies to poor women, but it applies to all women whose health care is provided by the federal government. So that includes women in the military, women whose health care is provided through Indian Health Services, women in the Peace Corps, on and on and on. And so Roe in and of itself does not guarantee access. But also, we need to keep in mind what else was going on in the early 1970s. There was the beginning of the backlash against the civil rights gains of the 1960s. That's when we had the whole creation of the concept of reverse discrimination. You cannot separate Roe from the fact that 4 years later we had the Bakke decision, where a white male in 1977 claimed that he was discriminated against because of affirmative action programs that tried to increase the enrollment of non-white students in medical schools. And so Bakke won at the Supreme Court level a reverse discrimination suit. And that began the era of what some of us call the inversion politics, where the victims of racial discrimination were now being accused of being the perpetrators of racial discrimination. And now we see that, of course, in every avenue of life, even to where the majoritarian Christians are now accusing everybody else of persecuting Christians, as if they are not the majority of the people in this country. White men are accusing everybody of having it up against white men, on and on. I call it the era of inversion politics. But that also began in the 1970s. In response, black women in particular, women of color in general, had to engage in what is now called intersectional feminism, where we had to fight for, of course, reproductive rights, women's rights, but we also had to fight against the backlash against civil rights. We were part of the anti-war movement. We were part of the anti-apartheid movement. And in many ways, that separated us from the mainstream women's movement, because you could not see evidence that the mainstream women's movement cared equally about these non-gender issues as we did as women of color, particularly when it came to things like the anti-apartheid movement or the development policies of the developing world, or police brutality, those kinds of issues. And in many ways, you saw people expanding beyond abortion rights as the sites of our struggle, which was very important. I guess in the interest of time, I should probably skip ahead and say, while we defended the pro-choice framework, we knew we had to go beyond abortion politics to satisfy all the sites of struggle that we had. And as a matter of fact, in 1994, a group of African American women asked the question, why was abortion isolated from so many other social justice issues? And we did so in the context of healthcare reform. 1994 was the time when Hillary Clinton was asked to attempt President Clinton's healthcare reform process. And at the time, it was believed that if the Democrats remained absolutely silent on the issue of reproductive health and abortion rights, then the opponents to healthcare reform would equally remain silent on reproductive rights and abortion rights. I really wish they would get over that myth, because it simply does not work. It didn't work in 1994, it did not work in 2009. Just because one chooses not to engage in a discourse around reproductive rights and abortion doesn't mean your opponents won't. And you see ground to your opponents when you allow them to define the nature of the debate. But anyway, in 1994, a group of us African American women challenged the Clinton administration by taking out a full-page ad in the Washington Post demanding that reproductive rights and abortion rights be included in healthcare reform. And we called ourselves Women of African Descent for Reproductive Justice. And so from then on, the framework of reproductive justice became our dominant framework as women of color, which went towards challenging in many ways the privacy-oriented pro-choice framework. Not to supplant it, not to discredit it, but to say that there is no way to satisfy our needs by neglecting the social justice and human rights issues of women's lives with only a privacy argument. I'm not sure if I said that well. But the reality is that every time a woman is pregnant, or even thinks she's pregnant, she has what we call the oh my God moments. The oh my God moments are the things that go through your mind where you say, my God, do I have health care? Will I get fired from my job? Will I have to drop out of school? Oh my God, what will I tell my partner? Oh my God, what will I tell my mother? On and on and on. These oh my God moments are those human rights issues that we often find neglected by the privacy framework. These are economic justice issues. These are educational issues, all of these issues. And so when we created the reproductive justice framework, we expanded it because reproductive justice in a nutshell is the right not to have a child, which we joined the pro-choice movement in fighting for, the right to use abortion, the right to use contraceptives, and the right to use abstinence if one can hold on. There is a rumor that works. No proof, just rumor. But because we are from communities of color who are always having to withstand assumptions about our fertility, we have to fight equally hard for the right to have the children that we want to have, because we're always subjected to various strategies of population control, and that in a way separates us from the pro-choice movement. And then finally, the third pillar of reproductive justice is the right to parent the children that we have. So the right to have a child, the right not to have a child, the right to parent our children in safe and healthy environments, that is reproductive justice. And as you can see, it positions us far beyond the privacy argument of the pro-choice movement. Because we invoke the human rights framework as the legal regime under which we argue for reproductive justice, it also, in our mind, transcends the U.S. Constitution, which is far more limited in protecting the rights that we are demanding. So we are more likely to call on international human rights law standards and norms for the protections and entitlements that we believe we deserve, much more than trying to contort and twist the U.S. Constitution into that ill-fitting garment that is yet to acknowledge that women are full human beings. If you notice, we still do not have an ERA, an Equal Rights Amendment, to the U.S. Constitution, so we got a lot of work to do around the Constitution, which for a lot of people in the legal profession can be a bit puzzling. I've talked to many people who are lawyers. Some of my best friends are lawyers. And the word that they most often use and have recently taught me is that they wonder why we would make human rights claims because they're non-justiciable, whatever the hell that means. But from what I gather is that because the United States has refrained or refused to ratify most of the human rights treaties, that we cannot litigate them in U.S. courts, and then even the treaties that the U.S. has ratified, it has attached reservations, declarations, and understandings to them that keep them from being self-executing. Whatever all that means. The point is that when you invoke the human rights framework, the first effort one makes is not the legal effort, because we are a disobedient country when it comes to ratifying human rights treaties. Human rights offer us the their best power in this moment by the moral standards it lays out for how human beings should be treated. Right now, it's a race to the bottom of the well, in the words of Derek Bell. I mean, we really are adrift in determining that there is a human right to health care, there is a human right to education, there is a human right to social support. We don't even have the human right to have our economy managed in a way that it meets the needs of our people. It's managed in a way that it meets the needs of Wall Street. And so we invoke human rights for the moral standards that it sets for how our society should be governed, should be managed. And we also invoke human rights for its political dimensions, because we believe that human rights should be integrated into our political system. The simplest way that I can explain that would be, I would dearly love to vote for a candidate that's going to tell me how many children she's going to send to college versus how many children he's going to send to jail. We do not support our candidates based on their upholding of human rights. We support candidates for the most part based on how much fear that they can arouse in us, whether it's around gun control or illegal immigrants. And I shouldn't have to tell people in Arizona about the politics of fear. I mean, y'all are the Mississippi of the East. And so, before we get to the legal dimensions of human rights, we must recognize the power of the moral and political dimensions of human rights. And this is where the activists come in before we even get to the lawyers, because we believe that the law is only going to be as good as social movements make it be. And so we do not have a domestic human rights movement yet that can make our courts use the human rights framework. So let me close by talking about, now that we're in this period of strong inversion politics where the offenders, the people who want to support segregation, the people who want to support anti-gay legislation, misogynist legislation, they're the ones in power claiming that they're the ones powerless. You know, we're in full-blown inversion politics right now. What we need to recognize is that one thing we can do to offer a stronger challenge against them, particularly in their arguments around religious liberty now, because they're claiming that their religious freedom allows them the right to go way beyond the Bob Jones thing, where they talked about at Bob Jones University that they had a religious freedom to disallow interracial dating. Do y'all remember the Bob Jones case? This was back in the 70s when the IRS, I think it was the 70s, or maybe it was the 80s, when the IRS stripped the tax-exempt status from Bob Jones University because they said it was their religious right to discriminate against interracial couples. And the court said, you do not have a religious right to discriminate and receive tax-exempt status at the same time. You can discriminate, but you cannot receive the benefits of tax-exempt status if you do. And so they've been fighting a backlash movement around what they perceive as religious liberty, which is now morphed into a movement saying that they have the right not to provide contraceptive coverage if they are a religious institution, even to the point where corporations managed by a religiously minded person like Hobby Lobby's owner can say that I have the right not to provide contraceptive coverage because of my religious values to my employees. I mean, so we're in this whole debate on religious liberty around the freedom to discriminate. And I would just argue that one of the ways we can best use the human rights framework and the new framing that's come up against Cicero is to argue that while people who want to discriminate have freedom of religion, which is a human right, we who want to be free from that discrimination also have the human right to be free from religion. And so we need to argue against fetal rights and personhood and the diminishment of women's human rights and LGBT rights and civil rights as our freedom not to have someone else's religion's imposed upon our bodies and our societies. So let me shut up there and let's leave some time for Q&A. Thank y'all.
Mr. Hammond, oh, it's not on yet. There we go.
Mr. Hammond, Ms. Ross, thank you kindly for your words. We'll open it up to questions now. Who would like to go first?
I'm Leon Silver, and I sponsor the Liberty Project, and I'm going to moderate the question and answers here. So have at it. Right up on the aisle. There's a microphone right there in the middle, too.
I can talk pretty loud. Can you hear me?
Can you hear me?
My question is, if the government is in charge of our prisons, can you get an abortion in prison? And the other one is, what's a Dalcon
Shield. You want to talk about the Dalcon Shield? Do you remember that?
I know.
Why don't you do that one, and I'll do the abortion in prison.
There was litigation, I don't know, gosh, it's got to be decades ago now. I think over the Dalcon Shield and over, I think that the essential claim was false advertising. Dalcon Shield. There were ideas that you could insert the shield and it would protect you forever. And I think that's what undid the Dalcon Shield, but I don't know enough about that litigation to take it into account.
I could probably help a little bit on that. The Dalcon Shield was a long-term IUD. It was a triangular piece of plastic that was inserted at the mouth of the uterus, preventing semen from getting to the egg. It had a design flaw, not in the plastic itself, but there was a string attached to it that its only function was to allow a doctor to quickly pull it out when it was time for removal. The string acted like a bacterial wick of bacteria into the uterus. So it caused acute pelvic inflammatory disease among like 700,000 women. The reason that the litigation was taken up against A.H. Roberts was because they had internal memos from the 1960s observing this design flaw, and they chose not to correct it because of the profitability of the shield. And so that's what made them vulnerable to the lawsuits, because they knew it was defective and they chose not to fix it. One of the unfortunate consequences of that was that it discredited IUDs for almost 4 decades. So that this long-term contraceptive that may have been suitable for many women, other IUDs just simply weren't even put onto the market for fear that they would arouse the same kind of backlash that the Dalcon Shield deserved. So that's the Dalcon Shield. Abortion in prisons. We find that the federal government, not just the federal government, state governments as well, can be quite ambiguous when it comes to abortions in prison. Human Rights Watch, I believe, did a report, it's been about 10 years ago, proving that within some state correctional institutions, that the states were privately providing abortions to women who were incarcerated, particularly if the women were impregnated by prison guards. There were also abortions provided to women who were incarcerated because of their immigration status, and they didn't want, quote, anchor babies born here in the United States. So abortion provision is quite cynically used within our prison industrial complex, but it's kept very much on the hush-hush because it is the official government policy not to provide abortions. But even in the most vociferous right-to-life states, we see an underground of abortions being provided where it's around hiding the misdemeanors and the crimes of state authorities.
Your question up over there.
For Mr. Hammond, the issue of abortion is, I think for most men, it's difficult to bring it beyond an abstraction because it's something that's very gendered. It's the right to have an abortion is something possessed by women. And with regards to the Roe v. Wade decision, I'm wondering if Justice Powell or the other clerks, if you expressed any sort of awareness, was there a tension or a concern arising out of the fact that it was such a gendered issue with an all-male court making the decision, and what was that process like?
I think you asked a great question. The court not only was all male at that time, but it never had a woman on the court. The fact that the court has changed so dramatically, I think is certainly one of the, from a gender standpoint, one of the most important things that's happened to the United States Supreme Court. That there were at that time, I believe, only 2 female law clerks out of the 27 or 30 clerks on the court. So certainly the entire case was seen through the lens of men. I'm not sure that if the 9 justices were here that they would agree that this was a woman's issue. I think at least some recognition existed at the court at the time that it was an issue that affected all people, men and women. But certainly the stories, if you look at the Supreme Court's opinion, you can see that it is written very much from the perspective of a male-dominated society.
Do we have any other questions? All right, there's one over here. Let's take this one.
Leon, while she's going over there, I just, speaking of oh my God movements, I think I said earlier that Lewis Powell's daughter was the head of Right to Life in Utah. She wasn't. She was the president of Planned Parenthood.
Oh, okay. Thank you for correcting
Just
that. I wrote that.
All right, thank you very much. Thank you all for your questions. If you're here for CLE, there are some certificates in the back. Loretta has them. You got to make sure you sign in too, though. And we'll look forward to this next year. Thank you to our panel.